Thank you so much for joining us today for our presentation on extraordinary ability visas in the United States. We're going to talk about a number of visas during today's presentation, including the O-1A, O-1B, the EB-1, which is a green card, the EB-2 National Interest Waiver, or NIW, also a green card. Several of these are excellent options for entrepreneurs, which is also a very exciting aspect of these visas. And we're very fortunate to have my colleague, fellow senior associate Jiyae Hwang, here today to speak about these visa options. Jiyae has a wealth of experience navigating these on behalf of her clients, and she's going to draw from that to give us some background on these options as well as some helpful tips as you're choosing between them and understanding how to navigate them. A few things before we get started. Our firm is a full-service immigration firm. We do handle family-based immigration cases, humanitarian-based cases such as asylum, U visas, T visas, and we do have a focus on business immigration, including what we'll be talking about today. But we do encourage you to reach out to us if we can be of any help regarding really anything involving U.S. immigration. Now, we do a number of webinars each month. Our goal is usually at least 2 a month, but I think we're probably averaging about 2 a week at this point. So after this presentation, you'll receive a link where you can sign up for our future webinars, and we hope to see you on those. We'll also share with you the PowerPoint that you see on your screen, as well as a comprehensive guide to the National Interest Waiver, which again is the EB-2 green card option. We'll also send you a link where you can visit our YouTube channel. This presentation is being recorded, and we do upload the full-length webinars to our YouTube channel, as well as a variety of shorter videos. And again, those cover really the full spectrum of U.S. immigration law, so we hope those are helpful to you. If you have a question during the presentation, feel free to use either the Q&A box on Zoom or the chat function, and I will be actively monitoring those, and I'll either share the question with GA when it comes in, or I'll be sure to save them until the end of the presentation. But either way, we do plan to get through all of the questions by the end of the presentation, so don't hesitate to send in any questions. Without further delay, I will go ahead and pass it off to GA to talk about the different extraordinary ability visa categories. Go ahead, GA.
Thank you so much, Dustin, and thanks everybody for joining us today. The extraordinary ability visa categories can be a great option if the beneficiary can qualify. The O-1A, O-1B, for example, does not have a quota, so you don't have to go through, the lottery as does with the H-1B, for example. So it really can be a great option for many people. So let's start with a brief overview of each category. So the O-1A visa is a non-immigrant visa, and it is a visa for individuals with extraordinary ability in the sciences, education, business, or athletics. So entrepreneurs would typically fall under this category as well. And the standard to be granted the visa is that the person must be one of the small percentage who have arisen to the very top of their profession, very top of their field of endeavor. And usually what the government is looking for is evidence through extensive documentation of sustained national or international acclaim that will support that they are indeed one of the small percentage that have risen to the top of their fields. Now, the O-1B visa is also quite similar. The O-1B visa is a non-immigrant visa for individuals with extraordinary ability in the arts or extraordinary achievement in the motion picture or television industry. So movies or television, for example, right? And the extraordinary ability standard here is defined a little differently for these categories. So let's look at the standard for the arts. So the standard for extraordinary ability for the arts is that the individuals must have distinction. And what does distinction mean? It means a degree of skill and recognition that is substantially above that is ordinarily encountered in the field, such that the individual can be described as prominent, leading, or well-known in the field of arts. So you can already see that it is a little different from the O-1A visa category that we've talked about, the standard there, which calls for someone who has risen to the very, very top of their field of endeavor. You can see that the level of expertise that they're requiring for the O-1B is a little different. Now, let's look at the standard for motion picture television industry. So for that one, individuals with extraordinary ability is defined as someone who has a level of acclaim substantially above that of his or her peers. So you can also see that even in this category, they're not looking for the very, very top cream of the crop of the industry. They're looking for a level of acclaim, which means you are well known, substantially above that of your peers. So you can see that the O-1B visa has a slightly different way of interpreting what it means by extraordinary ability. Now, the third category I'll look at here is the EB-1A green card. So the EB-1A is not a non-immigrant visa. The EB-1A is a green card category. So if you apply for this immigration benefit, you will apply for an immigrant visa or apply to adjust status to a green card holder. And you will become a permanent resident of the United States as a result. So that is a direct pathway for the green card. And it is interesting that you do not need a US job offer to apply for the EB-1A green card. You can simply apply as an individual. So, which is quite an advantage, right? If you think about the other more traditional visa categories, which require sponsorship either by a relative of yours or either by a U.S. company that is giving you a job offer and goes through the labor certification requirement. That is the typical pathway to a green card. However, if you qualify for the EB-1A category, you can self-petition for your own green card. So that can be quite a decisive advantage for some people. Now, the EB-1A green card is reserved for individuals who have extraordinary ability in the sciences, arts, education, business, or athletics. And this just means that the EB-1A is one category that applies to all fields. So either, for the O-1A and the O-1B, there are specific fields that each category is designed for. However, for the EB-1A, it is just one category that applies for all fields. Now, what is the standard to qualify for the green card? The standard is that the individual must have extraordinary ability, which is defined as the individual being one of the small percentage who have risen to the very top of their field of endeavor. And you need to show through extensive volume of evidence that you sustained a national or international level of acclaim, and your achievements have been recognized widely in your field of expertise. And for all three categories, it is necessary to show to some degree that you will be continuing to work in your area of extraordinary ability in the United States. For in the case of an O-1A or O-1B, you do need a job offer from a U.S. entity. Now, keep in mind, though, that the U.S. entity could be an entity that is owned by the beneficiary, right? So if you are an entrepreneur, you could set up your own company in the United States, and that company can give you the job offer to qualify for the O-1A, right? For example. However, the EB-1A, you do not need any U.S. job offer. You can self-petition for a green card. What the EB-1A process requires is that the applicant themselves submit a signed statement describing how the applicant intends to continue working in their field of extraordinary ability. However, a formal job offer from a U.S. entity is not required. All right, so we will then move on and describe in a little bit more detail about each visa category and how to qualify for each visa category. So let's start with the O-1A visa. As I mentioned in the previous slide, the O-1A visa is for individuals in the fields of the sciences, education, business, or athletics. Now, to qualify for the O-1A visa, the beneficiary must demonstrate either having received a major internationally recognized one-time award, and for those awards, they really refer to very, very big deal awards like the Nobel Prize, the Pulitzer Prize, household name awards, right? So either you submit that evidence or you need to submit evidence that you meet at least 3 of the following lesser evidentiary categories that we listed here below. So let's look at the categories. Receipt of nationally or internationally recognized prizes or awards, and these awards are referring to lesser awards than the Nobel Prize or the Pulitzer Prize, right? So you can qualify for any other award that is nationally recognized or internationally recognized in your field, even if it does not even if it does not reach that level of, being the Nobel Prize of your field. Membership in associations in your field which require outstanding achievements. So, for example, it is very hard to become a IEEE fellow. For example, you need to go through a very intense vetting process where your career is evaluated by experts in that field. Now, having passed those evaluative stages, though, does mean that you have earned some sort of recognition for your outstanding achievements in your industry. So that can be evidence of your outstanding ability, and that is why membership in such selective associations could help your case. Publish material in professional or major trade publications, newspapers, or other major media about you and your work in the field. So this category is really asking for media articles that have been written about you. So if you have been interviewed in the media, and if the media article talks about your achievements in the field, you can include that as evidence meeting this category. And keep in mind that it must be major media, right? So what does major media look like? So obvious examples are things like the New York Times or the Wall Street Journal, right? But actually trade media, major trade media, for example, if you're a psychologist and the APA publishes a magazine and an article about you has appeared in the APA magazine, that could also help support this category. So definitely there is a way to make a variety of evidences fit under this category. The next criteria: original, scientific, scholarly, or business-related contributions of major significance in the field. So one thing that could be very important in collecting evidence under this category is getting testimonials from experts in your field. Really, what they are looking for is what have you contributed to the field over and beyond what is being done, the status quo, right? So they're looking for major achievements and original achievements, which can take the form of, new technology that you have developed that has been published in patents, for example. Research studies that you have published that has received a high number of citations. That can be one example of an original scientific contribution. There really can be various strategies you could take to collect evidence under this criteria as well. Authorship of scholarly articles in professional journals or other major media in the field. This is really asking for, if you've written an article for an academic journal. That is the classic way you can meet this criteria. But also, if you're someone who's active in business, right, and you may not really be doing academic research that is traditionally understood, but if you, for example, prepared a business review, and this has been published in the Harvard Business Review website or a blog or industry publication that is, of a major caliber. Let's say if you're an active contributor to a major tech publication like TechCrunch, and that has been published and has earned a lot of references in your field, that could also help to meet this criteria. So a variety of evidences that shows that you have published your own material in those major media could qualify. Now, turning on to the next category, high salary or other remuneration for services. That is quite straightforward to think about. You do need to provide evidences of the ordinary salary that you can expect in your category, in your field, to compare. So you do need to compare. You do need to provide that comparison in addition to showing how you yourself have earned a different amount of remuneration through contracts or other reliable evidence. Participation in a panel or individually as a judge of the work of others. And a classic example of meeting this criteria is through participating in peer review for a scholarly journal. And the reason why this works is because you are asked to evaluate the work of other peers in your field for selection in journals. And that falls squarely within the definition of what they're looking for. Have you been recruited to act as a judge of the work of others in your field? Final criteria here: employment in a critical or essential capacity for organizations and establishments that have a distinguished reputation. And distinguished reputation can be proven in multiple ways. So For example, if you were the chair of a committee in a leading professional organization that is well known in the field with a high number of members, that can be one way to show distinguished reputation. Longevity of an organization is another way to show distinguished reputation. So, for example, Shell Oil Inc. has been around for many, many years. And if you have served as head of an engineering department in a major way in Shell Oil, then definitely that will count as one of the evidences that can meet under this criteria, because Shell Oil is a major corporation with a distinguished reputation that can be shown through various evidences, including longevity. And if you can show that you have worked in a critical or essential capacity for the organization as a whole, really affecting important priorities for the organization in a leadership position or in another way. And expert letters from that organization can really help in building that narrative of how your role particularly was critical or essential. All right, so we can move on to the next slide then now. Let's talk about the O-1B visa. So as I mentioned in the first slide, the O-1B visa is for individuals in the arts or motion picture television industries. Now, similar to what we've just discussed for the O-1A, the applicant will have to demonstrate either one of the two things. So either if they have been nominated or received a significant national or international award or prize in that field, such as an Emmy or a Grammy, or evidence meeting under at least 3 of the following criteria that we listed below. So let's look a little closer at these criteria. Having been or will be performing in a lead or starring role in productions or events which have a distinguished reputation, as evidenced by critical reviews, advertisements, press releases, publications, contracts, or endorsements. So you can see that the evidence required is twofold. The first part is showing that your role is lead or starring, and second, showing that the production itself has a distinguished reputation, right? So those evidence under both of those parts of the criteria will be required. Critical reviews or other published material in professional or major trade publication or other major media, either by you or about you, which show that you have received national or international recognition for your work. So you can see that it is the language of those minor criteria are slightly different from the O-1A context, such that you can include either material that you have authored or material that talks about you in service of this criteria. Other criteria include evidence of performance in a lead, starring, or critical role for organizations or establishments with distinguished reputations. We have already talked about this. Evidence of a record of a major commercial or critically acclaimed success in the performing arts, as shown by box office receipts or record, cassette, compact disc, or video sales. Evidence of significant recognition for your achievements from organizations, government agencies, or other recognized experts in the field. And what is important here is who is giving the endorsement, right? So are you getting the endorsements from the leading organization, a senior official in a leading organization in your field? Are you getting an endorsement from a government agency? Are you getting an endorsement from a other recognized expert in the field? And what is the, what is the CV of that particular expert? Does that expert readily appear to be one of these leading experts in your field? So not only is the testimonial itself important, but also who is writing the letter is also important in this criteria. Finally, evidence of having commanded a high salary or other significantly high remuneration for services in relation to others. So we have discussed this in the O-1A context, similar to here. You not only want to prove that you yourself are receiving this high salary, but also you want to procure the comparative evidence from reliable sources that show the comparison between yourself and the average remuneration in your industry. All right, so then now we can move on to the next slide, and we can discuss a little bit about the differences between the O-1A and O-1B, which we have covered in previous slides, but we will look at it in a table. So what fields is relevant for the O-1A or O1B. The O1A visa is available for individuals in the sciences, education, business, or athletics. Now, the O1B visa is available for individuals in the arts and those in the motion picture or television industry. And the standard of expertise that they require is different for the O1A and O1B. So the standard of extraordinary ability for an O1A visa is you must show that you are one of the small percentage who have risen to the very top of your field of endeavor, such that you can show through extensive documentation that you have received national or international acclaim, sustained national or international acclaim. Now, for the O1B visa, the definition of extraordinary ability is a little different. So for the arts, what is required is distinction, a high level of achievement as evidenced by a degree or skill, and recognition substantially above that is ordinarily encountered. So that is the level of distinction that they're requiring. What about the motion picture and television? They ask for you to prove that you are recognized at a level of acclaim substantially above your peers. So slightly different language of extraordinary ability between the O1A and O1B context. Now, how long is the visa issued for? So the initial visa for both the O1A and O1B are issued for 3 years. Now, for extensions, you can apply for an extension if you are working on the same list of projects that you've initially applied for, then the extensions are for 1 year each. Now, you could potentially work towards getting a 3-year extension if you have a new set of projects that you will be engaged under. So for these new set of projects, a 3-year extension could also be contemplated. However, in both cases, you do need to show proof of existence of work in the United States. For both O1A and O1B, you do need to show that there is demand for that work. Can your family come to the United States? And the answer is yes. The O3 visa is for dependents of O1A visa holders or O1B visa holders. Now, one thing to note is that your spouse, if they're coming to the United States on O3, they cannot work. They do not qualify for work authorization. However, it is possible for your minor children to come to the United States and go to school on the O3. All right, so the final extraordinary ability category we'll be looking at is the EB-1A green card. So as I mentioned before in the previous slides, the EB-1A green card is applicable for all fields. So all fields, including the sciences, the arts, education, business, or athletics. And similar to the criteria that we looked at for the O1A and O1B, you either need to show that you have received a one-time major internationally recognized award, such as a Nobel Prize or a Grammy or Emmy or Oscars, for example, or show that you meet at least 3 out of the 10 criteria that they enumerate. And we don't have it typed here, but the language of those criteria are very similar to what we've discussed in the O1A or O1B context, and includes things like evidence of lesser nationally or internationally recognized awards, evidence of membership in association in the field, which require outstanding achievements of their members, evidence of published material about you, evidence of your original scientific, artistic, athletic, or business-related contributions to your field, evidence of your authorship of scholarly articles, and the list goes on. But you do need to show that you meet at least 3 out of the 10 enumerated criteria if you're not showing a one-time major award, such as the Nobel Prize or the Grammy. Now, let's talk a little bit about what the Kazarian analysis is. So one thing that is worth noting with respect to the EB-1A is that it is a green card, and practically the definition of extraordinary ability is going to be scrutinized very strictly. And one of the reasons why is because the O1A, O1B is a non-immigrant visa, but as opposed to that, the EB-1A is leading to permanent residency, a bit highly coveted privilege of, being admitted as a permanent resident of the United States. And once you become a permanent resident after 5 years, you can apply to become a U.S. citizen, right? So it is a direct pathway to all of those benefits. So naturally, the scrutiny on those types of visas, on this particular criteria, on this particular program, is very, very strong. So let's look a little bit at what the Kazarian analysis will entail. So the step one of the Kazarian analysis is they would ask, did you submit at least 3 out of the 10 criteria of evidences that technically would meet the plain language of the criteria, right? So for example, let's say you have authored 1 journal article, and let's say you have performed 1 peer review while you're, in your PhD program, and let's say you have 1 media article written about you somewhere in one of the major medias. Now, if that is all that you submit to the government, right, it will meet step 1 of the Kazarian analysis, because you did submit at least 1 piece of evidence that meets the plain language of each criteria, and it is at least 3 of the 10 criteria. But if that is all that you have submitted, you will be challenged on the second step of the Kazarian analysis, right? So what does the second step Kazarian analysis entail? It is the question that, taken as a whole, does the entirety of the submitted evidence in totality really describe a person who is truly one of the very small percentage of people who have risen to the field, right? So they look at not only the quantity, but also the quality of the evidence. So in step 2 of the Kazarian analysis, the government will look at both the quantity and quality of the evidence. So for example, if it is an award that you have submitted, right, how selective is the award? If it is the media article that you have submitted, like how many media articles are there? Is it an article in the New York Times, or is it an article that has been published in a university newsletter, for example? What is the volume of evidence as a whole? And really, does this person have a volume of evidence that is commensurate with the level the EB-1A criteria is looking for, right? So does the quantity and quality of the evidence show, paint a picture, right? Paint a persuasive picture of someone who has risen to the very top of their field and is recognized among their peers in the industry, that is shown through extensive documentation. All right. So now then, let's shift gears a little bit, and we can discuss the National Interest Waiver. It is also a green card category under the EB-2 category. And the criteria is a little different in quality than the extraordinary ability visas and green cards that we've discussed before, but it could be a good alternative in case someone, is at a level that is not exactly commensurate with the very, very top of the field that the EB-1A is looking for. But if they are operating in a field, for example, in critical technologies like artificial intelligence, for example, if those technologies that fulfill nationally important priorities for the U.S. government, perhaps the national interest waiver could be another option for a green card that could be considered for those individuals. So let's talk a little bit about the NIW and how you can qualify potentially for the NIW as an alternative option to those extraordinary ability categories. So to qualify for the NIW green card, the applicant must first show that they meet the EB-2 threshold requirement. So there are 2 ways to meet the EB-2 threshold requirement. The first way is to show that the individual has an advanced degree or its equivalent. So an advanced degree is defined as a master's degree or higher. So for example, a master's in science, a master in arts, MBA could work. A JD or MD could also work. A PhD obviously works. Or the equivalent of an advanced degree, right? So what is the equivalent of an advanced degree? In this context, it is calculated as a bachelor's degree in your field plus 5 or more years of progressive work experience in your field after you've earned your bachelor's. So progressive work is very important, right? So progressive work means that work that has increased in complexity and seniority as time goes on. And you will be expected to prove that your work experience was progressive through letters from your previous employers, for example, if you are trying to prove the threshold under this using that method to combine your bachelor's degree with 5 years of progressive work experience. And typically you would get a letter from your previous employer describing what your duties were and how those duties changed over time to really constitute increasing responsibility, increasingly senior duties, increasingly complex tasks, for example, to meet the progressive work experience requirement if you're trying to meet this with a bachelor's degree. Now, there's an alternative way you can meet the EB-2 threshold, and that is through showing that you have exceptional ability in the sciences, arts, or business. And that doesn't necessarily, ask for an advanced degree if you can show exceptional ability. And how do you prove exceptional ability? Now, one thing to note here is exceptional ability is different from extraordinary ability. Now, showing exceptional ability does not require to prove that you have reached the very, very top of your field, as does an EB-1A context. So to prove exceptional ability, you need to show that you meet at least 3 out of 7 criteria of these evidences that are listed here. And that includes things like official academic records showing that you have any degree relevant to your field, at least 10 years of work experience full-time in your field, evidence that you have commanded a high salary compared to others in your field that, that shows your exceptional ability in the field, evidence that you have been recognized for your achievements in your field through, things like awards, things like, media mentions, things like, those public recognitions of things that you have done in your field that really set you apart from others in your field. So really, the totality of the evidence that you submit must really show that you are operating at a degree that is significantly above what is ordinarily encountered in the field. Now, that is a high standard, but definitely lower than the extraordinary ability standard we've been talking about, which requires somebody to show that they have reached the very, very top of their field, being among the small percentage who have reached the very, very top of their field through sustained national or international acclaim. But it is notable that the exceptional ability category does not require you to, possess expertise at that high level. So now let's say that you have proven that you have met the EB-2 category, threshold category, through either showing an advanced degree or showing that you have exceptional ability in the sciences, arts, or business. The next step is to show that your profile actually qualifies for the National Interest Waiver. And there are three prongs to satisfy in order to prove that you qualify for the NIW. And the reason why this is necessary is because the ordinary pathway to a green card in the EB-2 context is by showing that you have a job offer from a U.S. Entity, and the U.S. entity must have gone through what is called a labor certification, which is testing the labor market to see if there is any other qualified U.S. individual who can serve that role to replace you. However, for the NIW, if you qualify under the NIW, you are exempt from going through that labor certification process as a whole. So you do need to provide evidence that you do meet the 3 criteria for the NIW, such that you're able to self-petition for a green card as opposed to going through the employer sponsorship process as the traditional route, right? So let's look at the 3 eligibility criteria. So the first criteria is that you must prove that your proposed endeavor in the United States has both substantial merit and national importance. And what does this mean? So substantial merit can be proven in a wide variety of fields, including business, health, education, science, technologies, and endeavors that further human knowledge in those key areas. For example, if your work will lead to medical advances, for example, if your work will lead to advancing civil engineering, if your work will lead to strengthening infrastructure for the government, right? And can your work be tied to a strong positive economic impact? That is another major consideration when we're discussing substantial merit and national importance. What is the future impact of your work, and how is that important to the United States? And one thing that can be really useful in this exercise is pulling government reports and executive orders that pinpoint key industries and key fields where advancement is needed, and really showing how your work has the potential to introduce advances in those key areas could be very helpful for meeting this first prong. Now, the second prong of the national interest waiver criteria is that you yourself are well positioned to advance the proposed endeavor. And here, you would collect evidence regarding your education, experience, and really record of success in previous related projects related to your proposed endeavor. So if you are an entrepreneur, you would pull data from any metrics of growth and hiring that you have made in the past, for example, case studies from previous projects that have been widely recognized as an innovation in the industry, for example. Really, the types of evidence you could collect to support how you have the skills and knowledge can run the gamut, and really come from many different sources in your professional life. Now, the third prong to prove is that on balance, it would be beneficial to the United States to waive the requirements of a job offer and a labor certification for your particular case. And you can do this in a variety of ways, right? So you can emphasize your strength in prong one. So if your work has the potential to lead to broad systemic benefits to the field as a whole, you would emphasize that you would bring outside benefits than one particular worker could bring. So on balance, it will be beneficial to have you advance this work rather than, replace the job with another worker with minimum credentials. You can also rely on prong two. Really emphasize the unique know-how and experience that you have that other U.S. workers with minimum qualification will not have. Finally, there are some special considerations you can talk about. If you're an entrepreneur, for example, if you can show that your work would offer substantial positive economic benefits to the United States, such as job creation, generation of tax revenues on a substantial scale, that could really help prove that on balance, it is beneficial to allow you to come to the United States to do your endeavor and create those outsized impacts, as opposed to, keeping with the requirement of a labor certification and preserving one job spot for one particular U.S. worker.
So, Jiyae, a question came in. You
Yeah.
mentioned professional memberships. Does the date you joined the professional association matter if you're already working in the relevant field?
The date that you join the professional membership, no, not really. So as long as you're already a member by the time you file, it should be fine. However, the totality of the evidence must show that you have sustained national or international acclaim. Well, I am thinking you're talking about the EB-1A criteria. Then sustained national or international acclaim mean that you have had this recognition for a while. So if all of your memberships and all of your evidences are just from the like a few months before filing, then that could also be problematic. So you may want to bolster your evidence with other evidence of you being recognized in your field from earlier on in your career.
Perfect. Thank you.
Yeah, no problem. Yeah, so we can continue discussing the material. So the next topic is expert opinion letters. So expert opinion letters play a very important role in extraordinary ability petitions in general. And both O-1 petitions, both EB-1A petitions and NIW petitions rely on expert letters to really contextualize the applicant's achievements and to, support the applicant's significant contributions to their field and to their acclaim, and what are their abilities, right? So the purpose of expert letters in each category is a little different. So for example, for the EB-1A and O-1A extraordinary ability petitions, the experts, the purpose of having the expert letters is to confirm that the person has extraordinary ability in the field and is well known in the field, and that they have sustained national and international acclaim. For the NIW letters, the function can be a little different. So one type of letters can talk about the national importance of the proposed endeavor, such as a letter from a government agency talking about why a particular innovation is needed in a particular field and how the applicant's specific project can help advance the status quo in that area. Another type of NIW letters can talk about the applicant's contributions in their field, their past achievements in related projects that can help, that they are well positioned to advance the proposed endeavor. So those can take the forms of previous employers talking about the applicant's leading role in a particular project that resulted in a significant impact to the field, such as the development of a new technology that was commercialized broadly. So it is important to consider who is writing the letter, especially for the EB-1A O-1 criteria. Peer leaders in the industry is very important as letter writers. You want to get letters from people who are holding senior positions in leading institutions in the field with very impressive resumes that really could bolster the credibility of the accounts that are given in the letters. So one easy way to think about it is you are asking leading experts in the field who typically have decades of experience to write in favor of you and really describe your achievements and why they make you a leading expert as well. Now, how does the individual know you? For most petitions, we recommend having a mix of independent opinion letters and inner circle experts, what I call inner circle experts. So inner circle experts refer to people who have worked with you in the past and can speak to your achievements in detail just because they have been personally involved. So, and this can take a variety of forms. For example, if you are trying to prove that you meet the criteria for EB-1A for a critical role in a leading institution with a distinguished reputation, for example. So if you have worked as an engineering manager at a high level in Shell Oil Inc., for example, you may want to get a letter from the CEO of Shell Oil Inc., or someone who is at a senior level who can attest to your particular achievements and explain why your role was critical or essential to support that criteria. By contrast, independent experts are people who have not worked with you before, but they know you through your work or through your reputation in the industry, right? And those independent expert letters can be very powerful in confirming that your abilities are outstanding in your field because you are well known, or that your future work stands to impact the field, right? For the NIW context, those independent experts can give an objective opinion about the level of your contributions, either your past contributions or your future contributions. So it is important to have a mix of those types of letters. Now, what would be the content of those expert letters? As I mentioned before, discussion of your work, recognitions, accomplishments, and achievements, and really developing the narrative of how does your work set you apart from others in your field, right? Because the key of these extraordinary ability visa categories is that showing that you're operating at a level that is substantially above what is ordinarily encountered. Or, you know, in the case of EB-1A, you want to show that you have reached the very, very top of the field, and you are distinguishable from a vast majority of other professionals that are working. So it is very important to use those expert letters to build a narrative of, and really persuade the USCIS officer about why your achievements are important. And in that exercise, being specific is very important regarding the developing the examples of your past achievements. Generalized statements and hyperbolic language are frowned upon by USCIS evaluators, and they will not rely on any statement that is not substantiated by concrete detail. So it is very important to work with a lawyer who can note these things where further detail may be helpful. We can help review the expert letters, and we can help provide guidance on what sorts of detail would be helpful in really building a persuasive case, as opposed to an expert letter that is formulaic or simply repeats the regulatory language. Those tend to not be relied upon by USCIS. All right, so then now let's talk a little bit about some strategic considerations on choosing which category you should apply for if you're looking through those categories. So one question is, do you want to stay in the US temporarily or permanently, right? So as I mentioned before, O-1A and O-1B are non-immigrant visas. They give you a temporary ability for you to come and work in the United States. Note, though, that there is no lifetime limit on how long you can stay on the O-1. So as long as you continue to have demand for your work in your field in the United States, you can continue to extend your O-1 visa for as long as you wish. There is no 6-year, there is no 7-year limit, as opposed to other categories. Now, the EB-1A and NIW, by contrast, are both green card categories, right? So those categories are suited for people who do want to live in the United States permanently. And being a permanent resident of the United States has its own privileges, but it also has responsibilities. For example, you may be required to file a U.S. tax return, and there could be limitations on how long you can stay abroad. Abroad, as I mean, outside the United States, right? So if you maintain a strong connection to your home country, and if you need to sometimes stay in your home country for long periods of a time, if you become a permanent resident green card holder of the United States, there could be a limitation on how you can, how long you can do that. So definitely consider what your needs are. Definitely consider what your goals are in thinking of those visa categories. The second question to ask is, do you have a U.S. employer or agent, or do you want to self-petition? Now, the O-1A and O-1B both require a U.S. petitioner. That means a U.S. entity or U.S. person must be the one filing the petition. So you do need to have that technical connection to at least some U.S. entity or some U.S. person. It can be an agent, it can be your own company, but there needs to be that U.S. legal entity that will file the petition. However, the EB-1A and NIW, those allow self-petitioning by the beneficiary. That means you yourself, as a foreign individual, can be the driver of the petition. You can self-petition for the green card. You do not need a U.S. job offer. Even if it's a technical job offer, you do not need that. Although you do need a proposed endeavor, you do need, in the EB-1A context, you do need to submit a signed statement describing your intent to continue working in your area of extraordinary ability. However, a formal job offer from a U.S. entity is not required, and you do not need a formal U.S. entity to become the petitioner for your case. So that can be one advantage for some people. Family considerations, right? So O-1A and O-1B, spouses and children under 21 can join your application and come to the U.S. on O3 dependent visas, and spouses and children can study in the United States, but unfortunately, work authorization is not available for spouses. By contrast, the EB-1A and NIW are green cards, and once you become approved for a green card, your spouses and children can also apply for a green card alongside your own application. So that means if you're adjusting status in the United States, your spouse can also apply for work authorization, travel authorization alongside you, and everyone will eventually be eligible for a green card. All right, so other topics, other strategy points to consider, right? So one aspect to consider is the different standards and qualifications that apply for O1, O1A, O1B, and the EB-1A, right? So even though the regulatory language is very similar, just the fact that you were approved for an O1A or O1B does not mean that you will automatically be approved for the EB-1A. And one of the reasons why is that the EB-1A practically is scrutinized in a much stricter way. Also because, for example, if you're jumping from an O-1B to an EB-1A, the regulatory language of what is defined as extraordinary ability is different, right? So for the EB-1A, you do need to show that you have reached the very, very top of your field. You're one of the small percentage who have risen to the very top, as opposed to just requiring distinction in your field, substantially above your peers. So jumping from an O-1B to an EB-1A in particular could be a challenge. Another thing to consider is timing. Definitely consider how much time is left on your current non-immigrant visa if you're already in the United States on a different underlying visa, such as the TN visa, for example, because for the EB-1A or the NIW, once you file a petition like that, it is a petition for immigrant status. It is a petition for permanent resident status, and that can be evidence of immigrant intent. And some non-immigrant categories are very strict on looking at non-immigrant intent when they're approving the visa. So for example, once you file an I-140 for either the NIW or EB-1A category, it could be a little bit more difficult for you to renew your TN visa, for example, at the border. You could get challenged on immigrant intent for that. So definitely it could be a strategy issue to renew or extend your non-immigrant visa first before choosing to apply for the EB-1A or NIW. Definitely consult with your attorney if you're weighing these options. The final timing related question is family. Do you have children who may also need a green card? Children age out at 21 to qualify for the green card. So you can consider filing early on to avoid issues with children aging out. All right, so the next slide, are extraordinary ability categories available for entrepreneurs? And the answer is yes. The EB-1A and NIW both allow for self-petitions, which means entrepreneurs could apply on behalf of their own selves as entrepreneurs for their entrepreneurial work. Changes in the National Interest Waiver standard with the new matter of Denisar, which is the current standard, made it a much friendlier category for entrepreneurs, the NIW. One of the things that you can rely on is the argument of substantial positive economic impact to the field that could support substantial merit and national importance of your proposed endeavor. And also being an entrepreneur could help you in the third prong, on balance, beneficial to the United States to, grant you the NIW as opposed to following the ordinary rules of the labor certification, job creation, tax revenues. All of those economic benefits are things that could help you in winning the argument in the third prong. Finally, one thing to mention here is that entrepreneurs may also use the O-1A category potentially if they have a U.S. corporate entity that can act as the petitioner for your file, right? So if they qualify for the O-1A, one way to move forward for the entrepreneur is create your own U.S. company first, and then have that U.S. company issue you a job offer, and then you can process the visa through that entity.
Perfect. And while we're on the topic of the O-1A, a question about that came in. Here, basically, what are the specifications for the media and journals that can be used for published articles about the applicant or their past work?
Mm-hmm. So the media and journals, right? So one of the requirements is that it must be major media. And the major media status can be proven in a variety of ways. One way to prove it is to show circulation. A substantial circulation of the readership of the media is important in proving that a particular source is a major media. Really fact-specific inquiry, though, so definitely reach out to us for a consultation if you want us to look at your particular media article.
Perfect. And you mentioned before on the previous slide about how the standards are different. There are similar terms, but the standard is actually quite different. And this question is is really getting at that. This person got a national interest exception, which was something we dealt with very frequently 2 years ago,
Mm-hmm.
which allowed you to get a non-immigrant visa typically when COVID restrictions were much higher.
Mm-hmm.
Does that in any way, is that in any way relevant to an NIW or an O-1 or an EB-1 application?
Yeah, some of the arguments that you may use may, come in handy when we're trying to prove that your work in the United States has substantial merit and national importance, right? It will definitely depend on your particular facts, though, because the way that the government defines national importance is very, very particular in the NIW context, the EB-2 NIW context, as opposed to other contexts. So, yeah, reach out to us for a consultation, and we'll be happy to look at your facts.
Perfect. And in your experience, do you submit color in petitions or do you use another method like something visual, a comment box or something like that?
Very interesting question. I don't think it's frowned upon necessarily. We print mostly in black and white, and there could be many different ways to highlight particular parts. You could, write a box around it, and uh, yeah, definitely not frowned upon. I do question if, with the scanning, if the all of the color is even preserved or not. So it is a bit of an open question there. But yeah, if you need to highlight a part of your petition, and I do highly recommend highlighting. You could use many different methods. You can put a box around it. You can put comment boxes around it. Uh, but yeah.
Perfect. Jiyae, thank you so much for sharing your experience. Thank you all in the audience for the great questions. Please do keep an eye out for our email where you'll have a link to sign up for future webinars and to see the recording. And we hope to see you on those future webinars. Thank you so much.
Thank you, Dustin.